All right, we'll get started. Hello. Welcome to Where Are Wisconsin's Fair Maps, a virtual forum brought to you by the League of Women Voters of Dane County on why we must end partisan gerrymandering in Wisconsin and how we all can help. I'm Joy Cardine. I'm on the board of directors of the League of Women Voters of Wisconsin. I'm a member of the Making Democracy Work Subcommittee for the Dane County League, and I'm your moderator for tonight's forum. We expect a great turnout tonight. We have a great turnout tonight. Thank you so much for joining us. Please know that we are recording this forum for those who can't be here, and so you can refer back to it if you wish. It will be posted in a day or two on the League of Women Voters of Dane County's website. We have with us three exceptional speakers tonight who are all involved in some way with the effort to end gerrymandering. Doug Poland, the litigation director of Law Forward, Lafayette County Board Supervisor Chris Marion, and the executive director of the Wisconsin Democracy Campaign, Matt Rothschild. We're going to hear from them one at a time, and we will take questions for them. Please post your questions in the Q&A section. I will monitor Q&A and I will present them to our speakers. If you want to share events or resources, or if you want to chat amongst yourself, use the chat feature. We're going to use the chat feature too to share resources and events. So we will share links in chat, share questions in Q&A. We'll get started now. Our first speaker is Doug Poland. He is the litigation director for Law Forward. He'll help bring us up to date on just where are Wisconsin's fair maps, including the latest legal action. Doug successfully challenged Wisconsin's assembly legislative districts before 3-judge federal panels in 2012 and 2016. He served on the legal team that took the Gill versus Whitford partisan gerrymandering case to the U.S. Supreme Court. He also obtained an extension of the ballot receipt deadline for absentee voters in the spring 2020 Wisconsin election. He is a partner at Stafford Rosenbaum, LLP. Doug Poland, thank you so much for being with us. What's new?
Well, thank you, Joy. It's great to be here. I really appreciate the League of Women Voters of Dane County for putting on this presentation, this forum, and providing this educational opportunity for its members.
So yes, go ahead and tell us what is the latest when it comes to the redistricting reform in the courts.
Absolutely, happy to do that. Before I start into that, I'd like to make a comment on something that you had said, Joy, and that is usually when we talk about redistricting, or in the past when we have people's eyes would glaze over, and that was certainly true in my experience. In 2011. We filed a challenge in the federal court in Milwaukee to 2000 Wisconsin Act 43. That was the state legislative districting statute that was adopted by the legislature and signed into law by Governor Walker. We went to trial in that case in February of 2012, and you could have heard a pin drop. There was almost no media coverage of that. There were perhaps 1 or 2 reporters who were following it. The media simply didn't give it any attention, and neither did the citizens of Wisconsin. And when I look at where we are now, 10 years later, due to I think the efforts of people like Matt and others to really raise awareness throughout the state at all of the harm that was worked by this extreme partisan gerrymander that was put into place in 2011, people are upset. They're energized, they're motivated, they're upset. More than anything, though, they're informed, they're educated. And the League of Women Voters of Wisconsin, of Dane County, of many of the counties in Wisconsin are largely responsible for raising that public awareness. So I personally am very grateful to organizations like the League for doing that, like Wisconsin Democracy Campaign for doing that, because it's very important for people to understand that. I have kind of scrapped the talk that I had planned to give, and in talking with Joan Schwartz, Joan gave me a few issues that she said she's been asked about most lately. And so I'm going to talk about 3 sort of overarching issues here. And of course, happy to follow up on any of those in the question and answer period of time. One of the issues that Joan has said has been very important to the League's members, and she's received questions about, is this question about jurisdiction of the courts, state courts versus federal courts, in terms of who ought to be adjudicating what the new state legislative districts and congressional districts look like, what's the right court to be, what's the appropriate court to be in. And it's important, first of all, to note that there is what we call concurrent jurisdiction over legislative redistricting and congressional redistricting too. The state legislature is charged with both. So the state legislative redistricting is obviously when the legislature draws new state legislative districts. We have 99 state assembly districts. They are nested within 33 assembly districts. So we have 3 assembly districts within 1 Senate district. The state legislature also undertakes the task of congressional redistricting. So that is setting the boundaries for the 8 districts in which we elect representatives to the United States House of Representatives. That's the congressional redistricting part of it. So that's the legislature's obligation in the first instance to do that. Challenges to those districts can be brought in either court. They can be brought in the state court. They can be brought in the federal court. There is actually a little bit of a conflict over that, and there has been in the past as well. So in the past, we typically talk about the recent past when we're talking about redistricting. And this is in the era of one person, one vote. So in the 1960s, the United States Supreme Court had a series of decisions where it held that there was a constitutional requirement of proportionality among districts, meaning that the populations need to be roughly equal among different districts. Among congressional districts, that population has to be essentially the same, down to the person, meaning that among Wisconsin's 8 congressional districts, the population needs to be essentially identical. Among the state's 99 assembly districts, there is a little bit more leeway that's allowed in terms of the apportionment of people in each district. So we talk about population deviations. What's the deviation or the difference in the population from the least populated to the most populated district? And the courts have generally said that population deviations below 10% are presumptively constitutional. Not necessarily, but at least presumptively. And in an age where we do redistricting by computers with very sophisticated software, a lot of data, it's quite easy actually to minimize those population deviations. They can all be kept well below that 10% sort of threshold of presumptive constitutionality. So we have these standards that apply for population deviations. Now, the jurisdictional issue really has to do with between the state and the federal court. Again, they can be brought in either court. Since the time, though, of these one person, one vote decisions in the 1960s, other than 1970 or the 1970s redistricting, where there actually was an adopted statute that was signed into law. In each of the decades that follow, from 1980 up until this last decade in 2011, the courts were involved. 1980s, 1990s, 2000s, 2011. The courts were involved in each of those. And in each of those decades, the federal court, not the state court, ended up being the court where ultimately the merits of the case was adjudicated. It was decided. So the maps that were actually adopted ultimately were adopted by the courts. In 2012, the federal court in Milwaukee, this is a 3-judge panel. It's not just a single judge like we usually have. A three-judge panel ended up adopting new districts, 2 new districts in the city of Milwaukee, because it found that what the legislature had adopted for those 2 districts, Assembly Districts 8 and 9, violated Section 2 of the Voting Rights Act. So the federal court adopted new districts that it decided were appropriate, but otherwise, the rest of the districts that were adopted by the legislature and signed into law by Governor Walker remained intact. But the federal courts have adjudicated each of those disputes on the merits themselves. So, in other words, in the modern era, since the one person, one vote revolution of the 1960s, the state court, whether a circuit court or the Supreme Court, has never decided these cases on the merits. And indeed, back in the 2000s, there was what we call a rulemaking petition that was taken up by the Wisconsin State Supreme Court, where the state Supreme Court appointed sort of a blue ribbon commission to look into this question about whether the state courts should adopt a procedure for litigating redistricting disputes, much like the federal court has. And at the end of that decade, in 2009, there was a penultimate public hearing where the state Supreme Court, which at that time had Justices Rogensack and Ziegler as members, and Justice Prosser also as a member, they reached the decision that they were not going to adopt a specific procedure, a specific rule for adjudicating these cases, because they felt, in their view, that these cases involving legislative redistricting were simply too political for the state Supreme Court to handle. So we had a number of conservative justices, or justices who were generally viewed as being in the conservative wing of the Supreme Court, including Justice Prosser, who was a plaintiff in a redistricting case back in the 1980s, who had been a sitting state legislator, and then a Supreme Court justice who said, these are simply too political for the state courts to handle. So they have refused to handle them in every situation. And even this past year, there was a petition for a new rule that was brought to the state Supreme Court by the Wisconsin Institute for Law and Liberty. And it asked the state Supreme Court to adopt a procedure for adjudicating redistricting disputes. And again, the Wisconsin State Supreme Court decided it didn't want to do that. So it did not say that it would never become involved in those disputes, but it said that it wasn't going to do it. So we have no track record in Wisconsin of the Wisconsin State Supreme Court ever in the modern era considering these cases on the merits, deciding these issues as a matter of law. There's no body of jurisprudence or law. There's no procedural history or record or body of knowledge that's been built up about how to do this. There is no rule in place that would say this is how they're going to do it in the state courts. By contrast, when we look at the federal courts, we see a robust body of jurisprudence. There's a lot of law out there in the federal courts, both in the Western District of Wisconsin, that's the federal court in Madison, and in the Eastern District of Wisconsin, the federal court in Milwaukee. In our circuit, the Seventh Circuit, they've decided a number of cases that touch on these issues. So this is a well-trod path in the federal courts. These judges have heard these cases before. There's a good body of law, good body of knowledge out there. And importantly, and this is very significant, it's something that's lost on people oftentimes, many of the claims that are brought in redistricting cases are based on federal law, either the federal Constitution, like the Equal Protection Clause, or the Voting Rights Act, which is federal law. And so there is an inherently federal interest in having these cases adjudicated, at least some of the cases and some of the claims adjudicated in federal court. So that's historically where we've been. So again, there is concurrent jurisdiction. I'm certainly not suggesting that the state courts cannot hear these kinds of claims, but they haven't. They've not done it in Wisconsin in the modern era. They've all been heard by the federal courts. And so the federal courts generally have been the ones that everyone has turned to. So there is this question about whether this present dispute now should be heard in state court or federal court. And this sort of is a good segue into this question of where we are now, because there are 3 cases that have been filed in the courts. And some of the participants in this session may have seen that. The first case that was filed in the federal courts just after the census data were released. So the census data were released by the U.S. Census Bureau in the middle of August. I will stop and make a note here that earlier this year, there was an initial release of data by the Census Bureau, and people might have seen that. So in early April, the U.S. Census Bureau released what we call the reapportionment data. Those were statewide data, population data that was released for the purpose of apportioning seats within the United States House of Representatives. That was the purpose of that release of data, but those data are not the data that are used for actually redistricting state legislative and congressional districts within the state. That specific redistricting data wasn't released till the middle of April. And what the law says is that once those data are released, that redistricting data, that is when a constitutional claim comes into being for what we call malapportionment. And again, the case law from the 1960s from the United States Supreme Court talked about one person, one vote. Back in the beginning, they used to say one man, one vote. We know better now, it's one person, one vote. The idea is that the districts have to be equal in population. And once that new census data is released, then we can quite clearly see that because people die, people are born, people move in and out of districts over the past 10 years, we know that those districts are going to be imbalanced. They are not going to have equal population as is required by the Constitution. So as soon as those data are released, there is, legally speaking, there is a claim for malapportionment, and that is a federal claim under the federal Constitution. So the day after those data were released, there was a lawsuit that was filed in the federal court in Madison, and it was filed by a group of voters who identify as Democratic voters, and they filed that claim for malapportionment. The following Monday, which was a week ago yesterday, a group of plaintiffs that I and some other lawyers represent filed a complaint also in the Western District of Wisconsin. We also filed a malapportionment claim. The groups that I represent are nonpartisan in nature, as are the voters. So we're bringing the claims not based on a partisan lean, but based on their rights as voters, period, not preferring any specific political candidate or political party. There was a third case then that was filed in the Wisconsin State Supreme Court. That was filed by the Wisconsin Institute for Law and Liberty, and that was filed last week as well. And the Wisconsin Institute for Law and Liberty, or WIL for short, filed what we call an original action petition in the Wisconsin State Supreme Court. So WIL went to the State Supreme Court, and their petition asks the State Supreme Court to take exclusive jurisdiction over the redistricting dispute. They've basically asked the Wisconsin Supreme Court to take the legal issue of how the districts ought to be composed if the legislature and the governor can't decide, which is what we call an impasse situation. So the legislature will adopt the districts that it adopts after debate and robust debate and in a hearing. That will get presented to the governor for the governor's signature or veto. Governor Walker in 2011 signed that legislation, and we'll see what Governor Evers does based on what he's given. If they do not agree, that would lead to an impasse like we had in the 1980s, in the 1990s, and in 2002. And in that case, the court has to decide. So WIL has asked the state Supreme Court to decide that issue. And we have two other cases pending in the federal courts that have asked the federal court to decide that issue. So that's sort of the way that the cases are lined up in the two courts. Now, since the time that the cases have been filed, the state Supreme Court has instructed the Wisconsin Elections Commission, which is the defendant in that state original action proceeding, to file an answer to WIL's petition by this Friday. And any friends of the court, or what we call amici curiae, because lawyers like doctors have to talk in Latin to confuse everyone, those briefs are due on September 7th. So on September 7th, a number of different non-parties to that case, including my legal team and our clients, will file a brief with the state Supreme Court in which we set forth our position. Similarly, there are a number of different actors that have filed motions in the federal cases asking to join the federal litigation. So WIL has done that. They've filed a motion to intervene in the federal case that the other group of plaintiffs filed. The Wisconsin State Legislature has moved to intervene in both cases, and they've already been permitted to intervene in the case that the other group of plaintiffs filed. Recently, just as of, I think, Monday, the group of Republican congressmen from Wisconsin have also moved to intervene in the case that the other group of plaintiffs have filed. So we have very clearly people have lined up in the two different courts, and there will be a battle essentially over where the case is heard on the merits. The final topic that I just wanted to address here in the last few minutes that Joy had flagged for me was a mapping procedure that would be used by the courts? How are the courts going to decide if there is an impasse and the courts have to adopt maps? How do they do that? What are they going to do? Well, the last time the court did that was in 2011 or 2012, at least with respect to the two state assembly districts that we challenged as having violated Section 2 of the Voting Rights Act. And when that was done, the court in the first instance had turned to the parties and said, asked us to submit configurations of the districts that we thought were appropriate. I'm sorry, actually, it had asked the legislature in the first instance to come up with new districts that would comply with the constitutional requirements. The legislature said it wasn't going to do that. Once the legislature signaled that it wasn't going to do it, then the court turned to the parties and said, okay, give us the districts that you propose. So we submitted ours. The defendants in the case submitted theirs. The court ended up selecting ours, and that's what are currently districts 8 and 9. If we look at the partisan gerrymandering case, the Whitford versus Gill case that we successfully tried to the federal court in 2016, and that resulted in a judgment in favor of the plaintiffs in November of 2016, there the court did a very similar thing. The court turned to the legislature and the governor first, and the court said, you need to adopt a new statewide plan that complies with federal requirements. And we will give you until November 1st of 2017 to come up with that, with those new constitutionally compliant districts. They decided they weren't going to do that. They appealed to the United States Supreme Court. Ultimately, they won before the US Supreme Court. But if they hadn't won, then they would have had their opportunity to come up with new districts that comply with the Constitution. If they hadn't done it by then the court would have taken suggestions from the parties, proposed maps. The court might have taken proposed maps from other groups that would have wanted to submit them. Again, we call those groups amici, or friends of the court, amici curiae. So federal courts generally will give an opportunity for the legislature to adopt compliant constitutional districts first, because that's what the legal authorities say that they need to do. They need to give the legislature that chance. But it doesn't mean that the federal courts have to stay out of the issue altogether. They don't have to do what we call abstain altogether. They can set a date by which the legislature has to adopt constitutional districts, or they will step in and act. And then they have a lot of latitude as to what they do. They can ask for submissions from the parties. They can ask for submissions from others. They can appoint what we call special masters, which are people, these are experts in the field who have knowledge about how districts ought to be drawn. They can appoint them and they can ask them to help the court to make that decision. So we're very early in the process now, just in the leading edge of it. We don't know how it's going to turn out. But it ought to roughly follow the template that we've engaged in the past decades as well. And why don't I stop?
Oh my goodness, we're just at the beginning, and there's all that already. It's amazing, really. You said we don't know where it's going to end up, Doug. But if you said in the beginning that the state courts have been very reluctant to get involved at all in this. So a lawsuit asking the state Supreme Court to take on the answer here, is that unlikely or likely?
Well, I think it depends on the factors that are most important to the state Supreme Court. The factors that have been identified before, and this was as part of this rulemaking petition process that went on last November and December and January, and culminated in a public hearing that the state Supreme Court held in January, where it took comments from 27 different groups and people, including myself. I think I believe Matt spoke as well. I don't recall. Matt can tell you, can shake his head yes or no. But there were a lot of people that spoke on that. And a number of issues were raised. And as I mentioned before, it includes that there simply is no track record there of the court having done that before. It includes the very strong concerns that had been raised by Justices Rogensack and Ziegler and Prosser back in 2009, that interjecting the state Supreme Court into a dispute that is inherently political at its core potentially could be harmful to that court. It includes the fact that the state Supreme Court it's a court of last resort. In other words, it is a court that hears cases after they've already started in the state circuit court, a trial court, where a trial court judge will hear evidence and hear facts and then make findings of fact and issue a decision. It goes up through an appellate court and then ultimately gets to the state Supreme Court. What Will has proposed is that the state Supreme Court take this case as a matter of a court of first resort rather than last resort, and that it preside over a trial and receiving and taking evidence and hearing testimony and all of that. That is not a function that this court typically performs. And then the final point is that many of these claims that are raised are claims that are inherently federal in nature. They arise under the federal Constitution. They arise under the Voting Rights Act. And this is a court that simply does not have any experience with, or certainly no experience with Section 2 of the Voting Rights Act and very little experience with federal constitutional claims. So I think it depends on how the justices of the Wisconsin State Supreme Court feel their position to be able to adjudicate this dispute when it's going to involve significant fact-finding on sophisticated issues of federal law.
If you have a question for Doug Poland about the litigation and legal aspects of redistricting reform, you can type them into the Q&A section. Susan asks, and you may have touched on this just now, what is the difference between the original action petition filed by Will now and the one filed at the end of last year?
Sure, that's a very good question. So what was filed at the petition that was filed, that was heard at the end of last year was actually filed in June of 2020. And that's what we call a petition for a rulemaking. So this is something that the Supreme Court has within its inherent authority. It can make rules by which it will operate. So they were asked to adopt a rule that would essentially provide a framework for how redistricting cases would be decided, would be adjudicated and decided within the state Supreme Court. So it was a rulemaking petition for a rule, a process, in other words. What was filed with the state Supreme Court last week was an original action petition. Now that's actually a legal case. So rulemaking petition is not a legal case. It's not a legal action where someone is asking for a dispute to be resolved. What was filed last week was a claim that could have been brought in a state circuit court. Just like a complaint is filed in the state circuit court, any dispute, a dispute among landowners, among business competitors, whatever it may be, that was a complaint that was filed. But instead of filing it in the state circuit court, there is a statutory procedure that allows people to go to the state Supreme Court and say, for whatever their grounds are, we would like the state Supreme Court to take this case as an original action. We don't want it to start out in the circuit court and move up through the appellate courts. We want it to go to the state Supreme Court first, and for the state Supreme Court to be the sole court that adjudicates it.
Don wonders, if the Supreme Court would decide they are willing to take on the redistricting case, would that supersede any federal decision, or could the federal court override that decision?
So it depends on the issues that the state court would decide. On issues that are purely issues of state law, the Wisconsin State Supreme Court has the final say on those. It is the court of last resort, the highest court in the state of Wisconsin. So any questions that are inherently based on state law, it has the final say. On any legal issues that are inherently federal in nature, so a violation of the federal Constitution or a violation of the Voting Rights Act, it does not have the final say. The federal courts have the final say, and there the United States Supreme Court is the court of last resort, or the highest court. So if the state Supreme Court were to grant this original action petition, and it were to hear a redistricting challenge, and it were to decide on what state legislative and congressional districts should be, that could be challenged in federal court based on any of the federal grounds to do that, any of the constitutional grounds of the Voting Rights Act. And so you could have this procedure that goes forward in the state court that the state courts have never done before. They could end up with some kind of an answer at some point in time. And then depending on how they rule, that we could basically start over at the beginning again in federal court with a challenge to what the state Supreme Court decides, which is a highly inefficient procedure, to say the least.
Lashandra asks, what does the Constitution say about how redistricting should be handled? And this is related, how does the current map violate the Constitution?
And I'm sorry, was that question, was that the state constitution or the federal constitution?
I'm assuming state constitution.
Yeah, so the state constitution puts the obligation to redistrict on the state legislature in the first instance. So the state legislature has the obligation to take that up in the first instance. There are only a few criteria, strictly legal criteria, that the state constitution sets for how state legislative districts need to be composed. They have to be compact, they have to be contiguous, they have to essentially follow the local jurisdictional boundaries, municipalities, wards, counties, boundaries. But beyond that, there are some what we call traditional redistricting criteria, things like respecting communities of interest. So those are the criteria that we have under the state law. How does the current map violate those particular criteria? Well, according to what the federal court held back in 2012, it doesn't. We brought challenges back in 2012 that were based on the state constitution and state law. For example, in 2011, the redistricting that the state legislature engaged in was one of the most radical reworkings of the districts that we've ever seen. They moved roughly half of the state's population into new districts. We challenged that. We said that was a gross violation of state law and federal law as well. The federal court disagreed with us. They said they were troubled by it. They thought much of it was unnecessary, but it was an enacted plan. And so they thought that it didn't violate the standards that we had argued it violated. So they found that it was actually okay. What they struck down in 2012 were districts in Milwaukee based on federal law. That was Section 2 of the Voting Rights Act. So they found that it didn't conform to federal law.
Okay, we'll get to more questions for Doug Poland after we hear from our other guest speakers, and we'll hear questions for all of them at the end of their presentations. But we should move along to stay on time, and our next speaker is Chris Marion. Chris is a small farmer. She's a B&B owner-operator in Southwest Wisconsin. She's serving her third term as Lafayette County Supervisor. She has a particular concern for rural communities, main streets, small businesses, and family farms. She believes gerrymandering disenfranchises all of these stakeholders. Welcome, Chris. Thank you so much for joining us.
Thanks so much for having me. It's just wonderful that you're having this event. I'm going to talk a little bit from a much more anecdotal perspective as a candidate who ran for state Senate and state assembly in the last two cycles, in what is actually considered to be one of the more competitive gerrymandered districts in Southwest Wisconsin. I have been a proponent of fair maps since before I lost twice in a gerrymandered district. In my first term as Lafayette County Supervisor, I brought a fair maps resolution to the county board, which failed. And I've brought them in each year I've been a supervisor, and they've always failed. One of the reasons I decided to run for state Senate is I went to a lobby day on fair maps, and I met with my senator, Howard Markline, asked him with a bunch of other people to consider the Iowa model for fair maps. And he told me it was too expensive and that he's talked to lots of people in Iowa and they don't like it very much anyway. So that kind of energized me to make a change. And I can tell you that talking about gerrymandering, advocating for fair maps is one thing, but when you run in a district that is gerrymandered, you feel it from a whole nother perspective. The main thing that you learn is that representatives in gerrymandered districts don't need to be responsive. They don't need to be known, and they don't need to know their districts. And I think that is what makes gerrymandering the single most important threat to our democracy as a nation, because it removes the fair representation that this country was founded on. Our War of Independence was fought to get fair representation, and now we're kind of sliding back to that very same position that we were in when we became a country. And so I think that it's wonderful that people now know what gerrymandering is. I'll tell you, when I ran in 2018 and tried to talk about it, nobody knew what I was talking about. They certainly knew when I ran in 2020. And that is huge, a huge amount of progress. So I'm really grateful for that. My district, I'm not going to share my screen, but I'll share my map with you. Here's our fair state, and I'm in the southwestern portion. And the district I ran in 2018, the 51st Senate, starts at Necedah up here, top of Juneau County, goes all the way down, cuts Sauk in half, Iowa in half, is all of Lafayette, cuts out a little bit of Greene, takes all of Grant, takes Richland Center, a little bit of Vernon, and a little bit of Monroe. It's completely irrational. And in order to cover this district, which is 2.5 hours from top to bottom, especially on our curvy country roads, I bought a camper. And I needed to stay overnight so often that I bought a camper to haul behind my truck. And that's how I ran my campaign. I was in 50 parades. And many of those, that was just in one summer, one cycle. And I sometimes had 2 hours between parades. And I would oftentimes pull right into the back of the line of floats and just be the last. I was the last float in many, many parades in 2018. And it's really quite something to try and be present and understand the issues facing 9 different counties. Where I live in Lafayette County, we're dairy country, rolling hills, driftless. Necedah, Juneau County, is sand country. It's potato growing, and it's a very different landscape. It's very different issues, and just a completely different districts, and they shouldn't be in the same Senate district. An interesting result of the spread is that people don't expect to see their representatives. In fact, I spent a lot of time in a lot of communities. I ran full time. I stopped running my B&B for the year. And oftentimes people would say to me, including in the village of Spring Green, where my opponent lived, I've seen you more in this summer than I've ever seen Mr. Markline. You've shopped here more than he ever has. That's really telling. I think that is the crux of the problem. And when I knocked on doors, so I knocked on thousands of doors, quite often when I started to say why I was knocking, I would talk about the senator who was in office. Most people didn't know who he was. They never heard of him. So that's really important. And I think that when you don't have to be responsive to your district, it means that you lose touch. Not only that, but you become more radicalized. If that makes sense, what happens is, for instance, because my district is known to be sort of competitive, the first time this senator ran, he ran on a platform of being a moderate. And by the time I was running against him, he'd been in for 8 years, and his message was no longer moderate. There was nothing moderate about it. And I think that the polarization that we see in Wisconsin, which many, many, many people are uncomfortable with, I don't think many citizens fall comfortably into either the Democratic or the Republican Party right now, because we've been radicalized by gerrymandering. I think a great example is just recently, Senator Nass called Tommy Thompson, the former Republican governor, he called him an ivory tower administrator who's too into big government when he tried to have the UW system have some mandates regarding COVID. That would not have happened prior to gerrymandering. I think that we have really seen a big polarization between the parties because of gerrymandering, because what people generally like is being in the middle, is compromise. And we don't see as much compromise at the state level anymore. And I think that's probably the biggest loss that we have suffered, is we have a government that is now very dysfunctional and doesn't get a lot done because there's no more compromise. One of the things that was shocking to me, I'm a former journalist, was that there was no press coverage of my race, either for the Senate or for the Assembly. And I basically wrote a press release when I announced I was running. That got published in the papers as is. And then they asked me to fill out a candidate survey at the end and right near the election. And that's basically it. There's so little coverage of politics in a gerrymandered district because it's not really considered relevant, because it's a foregone conclusion. So you don't really get to hear people's positions on the issues. There were also no debates. I do want to thank the League of Women Voters for holding debates. I think you all carry enough weight that you can get people to come to the table, but it is very common, and this has become more common in the past 2 cycles, that incumbents do not accept debates. I sat at quite a few tables on a stage by myself, waiting for my opponent to show up, because there's no need to come to debates. It's quite shocking. Another thing that happens is representatives hold listening sessions in district now. And rather than a back and forth, when people ask them questions about issues, both of my representatives have said, this is a listening session. This is not a back and forth. I am here to listen. So basically, there's just no accountability for what's going on. And I think people aren't really able to follow the votes because there's just so little coverage, especially rurally. And that is due to a lot of things. The final thing is that in 2018, as you might remember, when Governor Evers came and we flipped, there were quite a few flips at the state level, and only, in fact, every single officer was Democrat. But in the Assembly and the Senate, only 1 seat flipped. And in fact, there were, in the Assembly, I think there were 33 of 99 seats that the candidate ran unopposed. So the incumbents didn't even have anyone run against them in 33 of 99 Assembly seats in 2018. In the Senate that year, there were only 6 races in the entire state that were decided by less than 10%. I was one of those, but it's very rare to see competitive races. And I don't think we're getting good government out of that. I don't think that incumbents are holding their seats because their constituents believe that they're doing a good job. In fact, when I knocked on doors, what I most commonly heard was, government's broken. You sound very nice, Chris, but you'll never fix it. All politicians are corrupt. And again, that is a heartbreaking thing to hear when you're knocking on doors for a year. And I don't want that for our democracy. So that's why I'm continuing to fight hard at my county level, trying to educate people at the state level, and in every way trying to push back on what is really an unconstitutional setup of rigged maps.
Thank you, Chris. Let's now hear from our third speaker, Matt Rothschild, the executive director of the Wisconsin Democracy Campaign. Prior to joining the Wisconsin Democracy Campaign in 2015, Matt was editor and publisher of the Progressive magazine. He is the author of You Have No Rights, Stories of America in an Age of Repression, and the forthcoming book to be published or released this fall, 12 Ways to Save Democracy in Wisconsin. And I'm pretty sure that banning gerrymandering is one of those ways. Thanks, Matt, for being with us.
Yes, it is, Joy. It sure is. It's one of the first couple chapters, actually. And thanks so much for that nice introduction, Joy. It's great to see you again. It's great to be on another panel with Chris Marion and Doug Poland, both of whom I respect a great deal. And I got to say, it's delightful to be back with Joy Cardine. I love being on the Friday Week in Review show that Joy used to moderate on Wisconsin Public Radio. I'd be on there every 7 or 8 weeks. And I was able to have a civil dialogue across the ideological divide with a guest from the conservative side because Joy insisted on it. She wouldn't let us throw mud at each other. Not that I wanted to. We weren't allowed to call each other names. That's not my style either. But we actually had to have a decent exchange of views. And we need to do that more in this state and in this country. And for some reason, Wisconsin Public Radio canceled the Week in Review right after Joy left. And I think that was a huge mistake. There are just too few opportunities in this state and in this country to speak across the divide. And we've got to solve that problem. We can't just stay in our little camps and throw firecrackers or mud at each other all day long and all night long. That's no way for the democracy to work. So I want to say to the league that you're lucky to have Joy Cardine. And I think Joy's lucky to have the league. You're all doing amazing work. Mm-hmm. I travel across the state, especially prior to COVID. And I've talked to a whole bunch of League of Women Voters chapters. I really admire the work that the league does and that all the volunteer activists at these league chapters do to sustain our democracy and to have real civic conversation on crucial issues before us, and also, of course, to do voter registration, get out the vote drives, which are crucial for our democracy to function. So I applaud all of you in the league. Let me get to the subject at hand, and let me state at the outset that, gerrymandering is wrong, period. It's wrong whether Republicans are rigging the districts. It's wrong whether Democrats are rigging the maps. No party should be able to keep itself in power just by moving a line here and moving a line there on a map. I mean, that's crazy. They don't have to change a single voter's mind. They can keep all the voters equal and constant and just move the lines around and finagle it so that they're in power for another 10 years. That's manipulation. That's kind of grotesque anti-democracy behavior, and it shouldn't be allowed. So, there was a possibility here that the Democrats could have solved this problem way back in 2009. I'm going to take you back in the time machine, because in 2009, hard as it may be for some of you to believe, the Democrats held the majority in the state assembly. They held the majority in the state Senate. They had a Democrat, Jim Doyle, in the governor's office. And thanks to Representative Spencer Black and then Representative Jeff Smith, there actually was not only a bill to ban gerrymandering, there was a hearing on a bill to ban gerrymandering. But the Democratic leadership decided not to bring the bill to the floor for a vote. Why was that? Well, I wasn't there. I've done some reporting on it. It's in my book. And the conclusion that I drew after talking to people, including Spencer Black and Representative Jeff Smith, is that political power is the most intoxicating drug on the market. And the Democratic leaders thought foolishly that they'd retain power in the 2010 elections and that they could then rig the maps for themselves, for the Democrats. Well, that was a huge miscalculation. As I'm sure you know, because the Republicans swept into power in 2010. They won the state assembly, they flipped the state Senate too, and Scott Walker became governor, as you know. And they wasted then little time in rigging the maps in one of the worst gerrymanders in modern American history, according to the panel of federal judges who heard the case in Madison. And I had the pleasure of sitting in on some of that court case. And I thought Doug Poland and his fellow attorneys just put on a tremendous case there. That was fun to watch. Actually, the voting rights, the voter ID case was going on at the same time in the same blue federal building downtown. And I would go up the stairs to listen to the ID case and down the stairs to listen to the gerrymandering case. So for those of us who are frustrated lawyers, and I come from a family of lawyers, that was kind of a fun thing to do. It's like being at the ballpark. So how did they rig the maps? Well, let's just look at how they did it procedurally. They did it in secret. They didn't do it in the Capitol. They didn't do the people's business in the Capitol, but they went across the street to the Glass Bank on the square in the cushy law offices of Michael Best and Friedrich. in a room that became known as the map room. And the map room was a locked map room. You, members of the public, weren't allowed in. The media wasn't allowed in. Democrats weren't allowed into the locked map room. Even Republican legislators who weren't in leadership couldn't get into the locked map room without permission of the speaker's aides, two young men who held the keys to the locked map room. And once those legislators were allowed into the locked map room, they could look at only their own redrawn districts. And get this, before they could leave the locked map room, they had to sign an oath of secrecy. Now, that's not what democracy is supposed to look like. That's not how democracy is supposed to operate. That's 180 degrees from how democracy is supposed to operate. Democracy is supposed to happen in public, in the sunlight, with a lot of public input and participation, not in a locked map room with secrecy oaths, not drawing maps by a political scientist who was flown in from Oklahoma, of all places, because he had the fancy software where he could, rig a map that didn't look like a salamander. Actually, the word gerrymander comes from Governor Gary or Governor Jerry in Massachusetts early in the 19th century, who rigged a map so badly that it looked like a mythic salamander. So people put the name Jerry and salamander together to get gerrymander, a name that is stood now and took now for 200 years. So that's gerrymander. I never knew the derivation before I came over to the democracy campaign. One of the problems, Chris Marion really delineated a lot of the horrible problems that flow from gerrymandering. I'm not going to go over those, but I think she gave a great presentation on that. What I'd like to do is focus on another factor, and that is cost. How much gerrymandering costs us. And it costs us every 10 years because we haven't solved this problem. Every time it goes into the court, it costs us. Spencer Black said he was furious that it was costing $1 million or $2 million. Well, it costs more now. Let's look first at the direct costs. Last time around, for instance, the out-of-pocket costs for lawyers that were on the taxpayer dime amounted to the tune of $3 to $4 million. This wasn't to improve our roads or to give us broadband or to increase, healthcare coverage or spending on public schools. This was just, and no offense, Doug, going to the lawyers. It wasn't helping us solve the problems of the state. We could have done a lot more with the $3 million or $4 million, but there it went. And now this time around, what's going on? Well, the speaker, Robin Voss, had hired to pay a pricey law firm in Washington, D.C., $30,000 a month starting in January, until Judge Elke voided those contracts at the end of April. So to me, that looks like there was $120,000 down the drain. And the old contract that the speaker had with this pricey law firm said that law firm would be getting $200,000 a month once lawsuits are filed. So I imagine that the speaker is trying to line up that law firm or another law firm at that kind of a price because lawsuits have actually been filed now. And the judge suggested if there was a suit pending, then the speaker might be able to hire his lawyers back on the job. We at the Wisconsin Democracy Campaign and Doug at Law Forward disagree with that. We think it's still a private interest that the speaker is using, and that it's a partisan interest, and that the taxpayers shouldn't have to foot the bill for a strictly partisan maneuver. They can only use public money for public purposes, is what we in Law Forward have said in a briefing. But who knows how the courts will rule on that one. To me, it looks like the legal battle, even if it goes miraculously fast, will last at least 4 months, or just about 4 months at the trial level. So if taxpayers are forced to pay, at $200,000 a month, that's going to be $800,000 right there. And what's more, the old contract envisioned paying another lawyer $375 an hour. This lawyer is former Deputy Attorney General Kevin St. John. I don't know how much he was paid, if anything, at the beginning. I don't know if his clock started ticking, but and I don't know how much he's going to get paid at the end, but I doubt it's going to be zero. It's going to be more than zero. So it's safe to say that fighting gerrymandering in the courts is likely to cost taxpayers $1 million before the end of the year. And that's before any appeals. And as Doug pointed out, the appellate process is inefficient. It's also really costly. So when all is said and done, this time around, we're likely to waste another $3 to $4 million on this fighting over the maps. And one of the great things about the Iowa model, which Chris mentioned, is that in Iowa for the last 40 years, they've been operating under a law that says the elected officials aren't the ones drawing the maps. They're the ones who approve the maps, but they don't draw the maps. The maps are drawn by career civil servants sworn to be nonpartisan, who operate under a specific criteria in the law that even if they wanted to be partisan, they couldn't be partisan because they can't use demographic political data about how folks in this district voted and how folks in that district voted when they're drawing the lines. And it's worked great in Iowa for the last 40 years, despite what Senator Mark Line has said, and it can work great here. And it barely costs a tiny fraction of this several $1 million that we're shelling out, every decade for this partisan legal fights. So those are the direct costs. Then there are indirect costs too, of course. If we had fairer maps over the last 10 years and a more balanced legislature right now, which those maps would have given us, we might have gotten the $1 billion in Medicaid spending by now. We might have gotten expanded Badger care for 91,000, low-income Wisconsinites. We might have gotten more spending on public education and on special ed instead of getting a dime on the dollar of Governor Evers's budget, which is what we got this time around. We also might have gotten medical marijuana, which 83% of the public is in favor of. When 83% of the public wants something and our elected officials aren't giving us that, there's something seriously wrong with our democracy. And one of the things that's seriously wrong with our democracy is gerrymandering. So what can we do about this problem? I've got a few suggestions for you, if you don't mind. The first is to submit maps or comments to the state legislature. Oddly enough, the speaker has acknowledged, tacitly anyway, the great work that the People's Maps Commission has done in soliciting testimony and gathering citizen input over the last many months. More than 800 citizen maps were submitted. And this is thanks in part to the great work of the League of Women Voters and the great work of Carlene Betchen at the Fair Maps Coalition, and also the great work of Angela Lang at Block. All of these individuals and their groups did a ton of work in getting people across the state to submit maps and submit comments to the People's Maps Commission. So not to be outdone, Voss has announced that he'll be taking citizen maps as well. So my suggestion is take him up on this offer. And to do that, all you got to do is Google Draw Your District, Wisconsin. Draw Your District, Wisconsin. Or you can go to the URL drawyourdistrict.legis.wisconsin.gov. That's draw your district, all one word, .legis for legislature, .wisconsin.gov, and submit away. Public participation is a good in and of itself. And if he draws a map that doesn't reflect that input, then well, shame on him. The second thing I want you to do is to urge Senator Dewey Strobel, and I'm going to spell his name. Dewey is spelled D-U-E-Y, and that's D-U-E-Y, and Strobel, S-T-R-O-E-B-E-L. Urge Senator Dewey Strobel and Representative Bob Swearingen, that's Swear, I-N-G-E-N, Bob Swearingen, to hold a hearing on the bills that are already introduced in the legislature right now that would ban gerrymandering and give us independent, nonpartisan redistricting along the lines of the Iowa model. The bill numbers are in the Assembly, AB for Assembly Bill, AB 395. That's AB 395, and Senate Bill SB 389, SB 389. So look, the people of Wisconsin have demonstrated in the polls and in their counties and in their municipalities time after time that they want fair maps. Can we at least get a hearing on this sucker? Is that too much to ask? I mean, it's just outrageous that we can't even get a hearing, much less a vote on these bills to ban gerrymandering, which is what the people want. I'm going to give you the addresses of these legislators. Most legislators have emails that end at legis.wisconsin.gov. So Dewey Strobel's is SEN for senator, sen.strobel, that again, STROEBEL, sen.strobel at legis.wisconsin.gov. So send him an email and demand a public hearing. And here's Representative Swearingen, rep.swearingen at legis.wisconsin.gov. We need to contact these chairmen of their committees. They're the ones in charge. That's where the bill's been sent, to their committees, and they've got to hold a hearing on this. The third thing I'd like you to do is I'm inviting you to the virtual lobby day for Fair Maps on September 27th. This lobby day is being sponsored by the Wisconsin Fair Maps Coalition. The League of Women Voters of Wisconsin is a member of the Fair Maps Coalition, as is the Wisconsin Democracy Campaign and a lot of other great groups. This is a day to pressure our legislators to vote in favor of these bills and to urge our legislators and Dewey Strobel and Bob Swearingen to hold a hearing on these bills so that we can actually get them to a floor, actually get them to a vote and hold people accountable, hold our legislators accountable. So for more information on this lobby day for Fair Maps, the easiest thing to do, which is what I did, an hour ago while I was preparing my remarks here, was just Google Wisconsin Fair Maps Lobby Day, September 27th, and you'll get all the info you need right there. And then fourth, if you're interested in process and participating in the process of redistricting at the local level, you can attend virtual local redistricting meetings. The Madison Ad Hoc Redistricting Committee meets every Thursday from 4 to 5:30 in the afternoon, and the Dane County Redistricting Commission meets on some Thursdays anyway at 7 p.m. to 8:30 p.m. So if you really want to get into the process of what local redistricting looks like, that's a good way for you to get involved. Lastly, I want you to be hopeful. I'm hopeful. Do you see that map behind my shoulder? I used to schlep that map all around the state when I was giving talks on redistricting 3, 4, 5 years ago, and it used to be mostly white. And now it's almost all purple. And that purple represents all the counties and all the municipalities that have now passed referendums or resolutions urging the legislature to ban gerrymandering. 56 out of 72 counties here in Wisconsin have passed these referendums and resolutions. And we don't have, of our 72 counties, we don't have 56 blue counties in Wisconsin. We don't have 26 blue counties in Wisconsin. This is an issue that crosses ideological lines. Wisconsinites just want fair play finally. They want a level playing field. They're sick of politicians manipulating the system and feathering their own nest and hoarding political power. That's why we're able to see in a poll from the Marquette Law School the fact that 72% of Wisconsinites want to ban gerrymandering. And of that 72%, 63% are Republicans and 76% are independents. This is a very popular democracy reform, and it's a crucial democracy reform. There's a reason these resolutions and referendums have passed, not only because it's a popular thing, because a lot of times popular things don't get enacted or get referendums passed on them. This one has taken off in part because both what Doug and Chris were saying, there's this amazing grassroots movement right now, which really gives me hope. It is this grassroots movement, a lot of it just spontaneous, that has erupted. And it's bigger today than it's ever been before. And lastly, I'm hopeful because all the nonprofit groups that I work with and the staff and leaders of these nonprofit pro-democracy groups in Wisconsin are working together. We're working together in the Wisconsin Fair Maps Coalition. We're also working together in the Wisconsin Voting Rights Coalition and a lot of other pro-democracy movements. These aren't paper coalitions. These are actual functional, dynamic, organic coalitions where we meet every week or every 2 weeks, and we plot strategy together. We organize together. We write op-eds and press releases together, and we organize together. We're all rowing in the same direction, and we're a lot closer to our goal today than we were 10 years ago, actually. So, we got to keep rowing. You've got to keep rowing, and we all got to keep rowing. And I'm just hopeful that we're going to get there. We're going to get to where we need to be. And I just want to end with the words of the great Irish poet Seamus Heaney. Once in a while, the longed-for tidal wave of justice can rise up, and hope and history rhyme. So hope for a great sea change. Believe that a further shore is reachable from here. My friends, it is reachable from here. Thanks so much.
Thank you, Matt. Thank you for that hope. Thank you for that inspiration and the kind words earlier. So let's take some of your questions. Type them into the Q&A section for Matt, for Chris, for Doug, about how we end gerrymandering, or any questions you have about redistricting reform. And I'm just going to start firing off some questions that came in earlier. Don wants to know what happens if redistricting might still be adjudicated by the date when districts need to be withdrawn. I think I understand that, and Doug, I hope you do.
I need to unmute. There we go. I think I do. So we've got regardless of whether the state court, the federal court, or both courts decide they're going to keep the lawsuits going that are going now, everyone agrees on one thing, and that is that the process needs to be given a chance to work. That's something that I have said since day one. Wisconsin's democracy has been so dysfunctional for the past decade that it would be a victory, I think, for the people of Wisconsin if the process worked the way that it's supposed to work. In other words, that the legislature takes testimony, it builds a record, it has robust debate on the floor of the Senate and the Assembly. It's going to adopt the districts, it's going to adopt it, then sends those to the governor for the governor's either signature or veto. That's the way the process is supposed to work. And if it works that way and it results in impasse, so be it. That's what the process is there for. And that would actually be, in my view, a victory given what's gone on the past 10 years. That looks like it's unlikely to happen until sometime in October. And so the litigation, regardless of whether it's state or federal courts, is going to respect that process. And the judges, whether it's the state court or the federal court, are not going to insert themselves into the process until that process has had a chance to work its way through. Doesn't mean the legislature gets to take forever to do what it's going to do. And in fact, there's plenty of precedent from the federal courts, including the United States Supreme Court, that says that the federal courts can give a deadline, a date by which the state legislature and the governor need to actually have a legislative solution to this or reach an impasse. And if it doesn't happen by that date, then the courts can start to act. So it won't give them forever, but it certainly will respect that legislative process for some period of time. And here, I think that means, at least sometime in October.
Okay. I have a few questions for Chris, including some kudos, saying incredible testimony and agreeing with you about how the listening sessions are a joke. But also the question was why did the redistricting reform resolutions fail in Lafayette County? You said that you tried to get them passed and they haven't done it yet.
Yeah, so the way county government works is everything similar to the state. There's a process of committees that things have to go through. And the committee in my county would be the Executive Rules and Legislative Committee. And the first year that I was on the board, I didn't know anybody all that well yet, and I had spoken to some people, but it failed because, as one of the gentlemen said, if it ain't broke, why would we fix it? Basically, it's working for Republicans, and my executive committee is very Republican because the committee is appointed by the chair, who happens to lean that direction. I mean, it's neither here nor there what party it is. It's just that it's working for the party in power right now. So if you are of that party, it is difficult to want to change it.
Yeah. Why would the Iowa model in a non-partisan drawing of the borders of the legislative districts be better for your district? Well, what would be different? What would be better, Chris?
Well, for my district in particular, well, I think that I am currently the head of my executive committee now, and we are essentially our redistricting commission for our county. We're very small, so we don't have a big process like some counties do. And I will say that you can have various values when you go into redistrict. You can have the value of, let's keep things very much the same as they are and just wiggle things slightly, just so that it feels very similar, so that people don't get lost when they go to vote, so that we don't change supervisors. My county lost 200 residents, so we're not dealing with a lot of change in our maps. But one of the values that a supervisor mentioned to me is that she'd like to see, she would like to see cities be whole instead of being basically carved up, put it basically in with a lot of township, because townships tend to be more conservative, cities tend to be more liberal, but of course the interests of the city are more like, and when you dilute both people's perspectives, right? You dilute the rural perspective and you dilute the city perspective when you put them into one district. So the 17th Senate district that I ran in, that is the value there was to make a long skinny pillar that grabbed a lot of rural conservative areas. They don't necessarily relate to each other. Sauk County split in two. For assembly districts, Richland Center, people who have a Richland Center address are represented by 3 different assembly people. So imagine like trying to figure out who to talk to and how to press your point when you're working with your legislators. I think what would change is the values would be, let's keep like communities together. Let's keep counties together. Let's keep cities and municipalities together. I think the Iowa model lists a number of values, and they operate along a number of values that are nonpartisan, right? Whereas now our largest value for those bigger districts is, let's make them keep the people who are in power. That's, I would think, a much lesser value than things like, let's keep counties together. If you're, let's keep school districts together, things where people are already working together in chunks. I think we should respect the chunks and not carve them up.
Let's direct this one to Matt. Susan wants to know, what is the likelihood that the governor and the legislature will reach a compromise on the maps because of their concern that the state or federal courts would reach a decision that both parties will think is worse than the compromise? I guess, are you hopeful, Matt, that that the legislature might pass maps that the governor will actually sign?
No, that's not one of the things I'm hopeful about, Joy. I think it's unlikely because the speaker has said many times that his fantasy is to have a veto-proof majority in the assembly. And to get there, he's going to need to rig some more districts. And so I believe that's what's going to happen. And, I'm a betting man, Joy. So I'm willing to bet that this gets to the governor's desk and the governor sees it as a rigged map and will take out his veto pen and veto it, and then on to the courts we go.
Joy, can I add one other comment to
Yes,
that? Quickly?
I was just going to ask you to.
Okay, thank you. We've heard several times, 3 times in particular in the past 6 or 7 months, first in January from the lawyer who was representing the legislature before the state Supreme Court in this rulemaking petition in January. Then in a series of texts from Joe Handrick, a former state legislative representative who has worked for Representative Voss for the last 11 years and was one of the drafters of the gerrymandered districts in 2011. And now, most recently, we've heard also from the Wisconsin Institute of Law and Liberty that what they are going to be urging the courts to do is adopt what they call a least changes map. If you remember earlier in the program, I said that in 2011, what the legislature did was to work one of the most radical reshapings of legislative districts in Wisconsin that we've ever seen. They abandoned, they moved half of the state's residents into new districts. Now they say what they want is a least changes map. In other words, sure, we smashed the cases and grabbed the jewels and ran away with them, but hey, everybody should be allowed to keep what the spoils of what they took at this point in time. So just like Matt said, they've already previewed what they're going to do. And yeah, Representative Voss might have opened this website for people to provide their input and their testimony and their thoughts, but the proof will be in the pudding. Let's see if they actually pay credence to that and pay heed to that and actually do something to adopt fair maps, or if they simply say, let's just keep what we worked so hard to do in 2011 and to rig the maps in favor of one political party.
Yeah. Do you, Matt, think opening up this website that Speaker Voss was in any way feeling any pressure from the advocacy efforts that are going on statewide?
I sure do. I think he felt pressure from the league and from the other members of the Wisconsin Fair Maps Coalition, and also a lot of pressure from the People's Maps Commission that did just such an admirable job of getting citizen input. They had hearings in all 8 congressional districts. They took maps from 800 people. They solicited comments. For those who didn't want the maps, you could just give your comments. They had expert testimony at these hearings, as well as just public testimony, any citizen who wanted to testify. And so I think Voss understood that if they're going to go to court, and he hasn't even waved at the possibility of inviting citizen input, that the judges might look unfavorably upon that if they were considering, say, the map that the legislature drew versus the map that the People's Maps Commission drew.
If you have a question, we still have about 10 minutes to go. If you have a question for Doug or Chris or Matt, please type it in the Q&A section. That's what I'm monitoring for questions. I see some are showing up in the chat section, but please type them in the Q&A section. And
Joy, can I ask Doug a question? Because I think
Yes.
I saw this in the Q&A or in the chat somewhere.
Mhm.
It's a timing thing. I mean, at some point, politicians who want to run for office in mid-December need to file their filing papers. What's the likelihood that a court's going to be able to decide by mid-December, and what if they don't?
Yeah, so the elections that are coming up in the spring are the ones where we have primaries in February, and that's where we need to have nominating papers that are circulated in December. It's a little bit, there is a connection between what goes on with state legislative districting and then the local redistricting for municipalities and counties, what they go through. The connection is that back in 2011, the legislature flipped the order in which districting was done. So before 2011, municipalities would go first. They would decide on their wards. They would then pass those wards on to the counties. The counties would put in place supervisory districts, and that went then up to the state legislature. And the state legislature would then pass legislative districts based on what the counties and the municipalities had done. But if you are the state legislature and you want to gerrymander, well, then you can't effectively, you can't take what's been given to you by the municipalities and the counties. You want to be able to do what you want to do and draw the districts the way that you want it to, unimpeded by what the municipalities and counties do. So they flipped the process around. They adopted a statute in 2011. It was 2011 Wisconsin Act 39. And in that statute, they decided that the wards, now the building blocks for municipal redistricting and county redistricting and state legislative districts were going to be census blocks. All right, those are common, and they're decided by the Census Bureau. And so now we've got a process where the municipalities and the counties, they still will do their thing, and they will adopt wards based on census blocks and county supervisory districts. But in the end, if what the legislature adopts conflicts with what the counties and the municipalities have done, then the counties and municipalities have to change the district lines that they've drawn. So we don't have any statewide elections this spring. They're all county and municipal elections, which means that as long as counties and municipalities have drawn their own local districts by the time nomination papers need to be circulated, that doesn't get affected in the first instance by what happens in the court with the state legislative districts. The caveat being that if the courts make a decision about what the state legislative districts need to do, and that isn't final until January or February, it's possible that that could conflict with what the states or what the municipalities and the counties have done in a way that they would have to go back and maybe alter some lines. So it's complicated, but what happens in the federal court doesn't necessarily need to hold up what happens with state and county redistricting.
Chris, you must be starting with redistricting on the county board level, are you?
Yeah, I mean, that's what I was saying. Our executive committee is the body that is doing it. And we've lost 200 people in the county. So there's not going to be a ton of change, but it's interesting, even at that level in a county of 16,000, so we each represent, there's 16 of us county supervisors. We each represent 1,000 people. And there's many, many ways you can wiggle those lines to achieve equal districts, which is what we need to do. And you can base that on a variety of values, as I was describing. And I think what we are likely to do is try and keep it as similar as it was, because that is the comfort level of most of the people on the committee. And we're only having we're having 2 times where the public can look at the maps and comment. So we'll see what happens.
Lots of people who want to know how to save the chat and all the links in the chat, and that information has been typed in the chat, so you can save all of that information by looking at the answers in chat. So thanks, and we appreciate that. If you have questions about redistricting reform or gerrymandering, please post those in the Q&A. In the Q&A section. We did have a question earlier that disappeared, just asking, what are the worst gerrymandered districts in the state? Matt, do you know? I mean, do you have
I mean, Doug did the suit, but I mean, I know Sheboygan was chopped up. I mean, this is what's called cracking, where they split off Democrats that were concentrated in cities and pushed them. For instance, Sheboygan was split in 2 so that the top half went into the northwestern part of the area there and so those Democratic voters got swallowed up and drowned out by the rural Republican voters. And then they did the same for the southern part of Sheboygan. They sent it into the southwestern area and where they got swallowed up. Also in Marshfield got split up several ways. And so that the Democratic residents who had the majority in Marshfield lost their voice, but Doug would know other examples for sure.
Doug?
I'll just say that we featured 3 of these in our brief that we filed with the United States Supreme Court in 2017. That's absolutely right. There are 2 ways that you actually accomplish a gerrymander. One is cracking and one is packing. And so if you want to gerrymander yourself, your own party in control, you pack your opponent's voters very tightly into districts so that there are way more voters for your opponent in those districts than is necessary to actually elect a representative that they favor. And then, like Matt said, you crack these other districts where you pull voters, your opponent's voters, out of those districts, and you pull them into districts that have a majority voters who want to vote for yours. So where we saw this really vividly, Matt's right around Sheboygan is one place. Another place is right around Milwaukee. So what the legislature did in 2011 was to take many of these districts that were out in the WOW counties to the west, and they ran them into the city of Milwaukee, and they pulled out a number of Democratic voters into those majority white and Republican dominated districts, so that you've got fewer voters left in the city of Milwaukee and Milwaukee County to be able to compose districts. And now their voices are basically drowned out. Down in Sheboygan, or down in Kenosha and Racine, they did basically the same thing. So they took those districts in those counties and they ran them into the cities of Racine and Kenosha to pull voters out, and into majority Republican districts dominated in the more rural parts of Racine and Kenosha.
Yeah, I'm gonna, we just about out of time here. Just maybe each of you give us your kind of closing remarks, your final thoughts, your takeaway for us on how we can end gerrymandering now. Doug?
Sure. Well, I'm going to go back to a point that was raised, I think, by everyone here, and that is that this happens by Democrats as well as Republicans. I lived in Chicago for 20 years, raised in the Milwaukee area, then in Chicago for 20 years. When I moved back to Wisconsin in 2005, I was so relieved to be getting out of a city and state where Democrats had really run roughshod for some number of decades, actually for a very long time, and getting back to what I thought was a really clean state. I'm devastated that we find ourselves in this position. But I think that Wisconsin it really is a purple state. And people really do want fairness. They want government that's fair and that works for everyone. And so you heard Matt and Chris both talk about things that each of us can do, each of you can do to contact legislators, to fight hard, to raise public awareness, to educate folks, to support the League of Women Voters of Wisconsin and Dane County, and tell the people what they want, and make your representatives responsible, hold them accountable, and make them support the Fair Maps process and a nonpartisan redistricting process.
Chris, you have some final remarks for us?
Well, I think if there's an issue that you care about and nothing's being done on it, you can draw the line to gerrymandering. It will never change whether it's Republicans or Democrats in power. We've proven that by talking about it tonight, until we have a nonpartisan process. So we need a legislative change so that it is not the legislature making the maps. That just has to change. I think until we, as the voters, demand a nonpartisan process, we are not going to get the kind of compromise and the efficient work done that we want to see in this great state. And I'm going to point just for a minute to environmental concerns as a top example. At one time, Wisconsin was a leader in conservation. Both Republicans and Democrats championed environmental concerns because we have a beautiful state, and a third of our income, a third of what we base our economy on is tourism. In this state now, our tourism is really hampered by blue-green algae and lakes that are drying up, and drawdown in rivers and streams, and the pollution of trout streams from various land uses. That is not something that Republicans want, Republican people. But somehow we've come to this polarization of environmental concerns, so that we have totally slid backwards in our protection of natural resources in this state. And I think we're going to continue to have heartbreaking situations like that, things that nobody wants. No one wants their kids drinking lead. Nobody wants to have PFAS in their wells and in their municipal supply. Nobody wants to turn on the tap and not know if there's nitrates in there. But we're not going to get a change until we are forced to compromise between the parties.
And Matt, you get the last word.
Well, I'm hopeful. I'm hopeful that we're going to get better maps this time around than we did last time, regardless of which court we end up in, whether it's state court or federal court. But the fact of the matter is, we're not going to be able to ban gerrymandering, this year. That's a long-term battle that we have to commit ourselves to for the next 2, 4, 6 years, so that by 2030, we've actually passed a law here that bans gerrymandering. And the way to get that done is to keep marshaling this public pressure, which the league is so good at doing, and make that pressure so hot and so high that no matter who is running, that person who's running has got to commit to banning gerrymandering and voting for a bill to give us independent, nonpartisan gerrymandering, independent, nonpartisan redistricting like they have in Iowa. And then we'll have this thing solved. It's a solvable problem. A lot of the problems we deal with, like the climate emergency and like racism and like economic inequality, don't seem that solvable. This, at least not in the short term. This one is solvable. All we got to do is get people elected who will commit to changing the law.
Thank you, Matt Rothschild, Executive Director of the Wisconsin Democracy Campaign, Chris Marion, who is the Lafayette County Board Supervisor, and Doug Poland, Litigation Director for Law Forward. Thank you, everybody, for joining us. Do look in the chat and get the information on Lobby Day. Fair Maps Legislative Lobby Day is Monday, September 27th, and it's a virtual event where you can meet with legislators and advocate for fair maps. And our next forum, I wanted to let you know, is going to be Protect the Vote on October 5th at 7 p.m. Our speakers will address the legislative efforts to restrict voting in Wisconsin, the multiple investigations into the 2020 election, and the need for national legislation that will protect and even expand the vote. So more information and registration is on the League of Women Voters of Dane County's website. That's Protect Vote on October 5th at 7 p.m. Thanks to all of you for joining us. For the League of Women Voters of Dane County, I'm Joy Cardine. Good night.